Can I ask the presenting teams to please turn on their cameras?
We also see the second oral list. Okay.
I'll just quickly welcome everyone to the final, where we've got a distinguished panel before us of Professor Ingeborg Frenzer as our presiding arbitrator, Professor Stefan Kroll, and Miss Louise Barrington. Without further ado, I will hand over to Professor Dr. Ingeborg Frenzer to lead us through the final.
Welcome, everybody. Good afternoon, good morning, everybody. I hereby open the virtual hearing in SIAC Arbitration 1 1991 25 Vis. AUKUS Worldwide Limited versus Darwin Natural Food PLC. And I understand claimant is represented by the University of Ghana too, correct? Could you please confirm, claimant?
Yes, please.
And respondent is represented by Middlesex University, Dubai 1, correct?
Yes, ma'am.
Thank you very much. Before we start, I wanted to ask both sides whether you agreed how to proceed with this procedure today and whether you came to an agreement.
No, Madam Presiding Arbitrator, the parties have not yet agreed to an order of proceedings, but we are happy to suggest the classic RCCR, with respondents going first on procedure, followed by claimant on the procedure, then claimant on the merits, and ending on respondent on the merits, for a total speaking time of 40 minutes per speaker, reserving a minute each for rebuttals and surrebuttals.
Is that agreeable to respondent?
Absolutely, Madam Arbitrator.
How about my two co-arbitrators? Agreeable?
Hello, am I audible?
Yeah.
Yes.
I wanted to say that I think is it Emmanuel who just spoke? Is there a chance of getting closer to the microphone or turning your sound up? Because I found that your voice is very quiet.
Now you are muted.
Unmute.
Madam Arbitrator, please, are you referring to Team Ghana or Team Middlesex?
Yes, Ghana.
Ghana.
Okay.
Yes.
Okay. Yes. Please, would you like me to take the order of proceedings again?
Now, just my co-arbitrator just asked you to go closer to the mic so that
Okay.
you're better audible.
Yes, please. Members of the tribunal, does this work much better?
This is good.
Yes.
And can we hear your partner as well?
Hello, members of this tribunal. Am I audible?
You are now,
Yes.
yes, yeah. Thank you.
Thank you.
Okay, so my two co-arbitrators, can you agree to the procedure suggested by the parties?
I would like to have the little bit more rebuttal. Yeah, we are in the final. We have we want to give you more time to present your case in return to their questions. So if you want to have 2 minutes on rebuttal, I would prefer that than having just the 1 minute.
Fine by
Yes,
the parties?
Yes, ma'am.
Yes, please, that works for the claimant.
Okay, then you may start, counsel for respondent, please.
Honorable members of the tribunal,
My name is Hiranmay Pujari, appearing as respondent Darwin Foods PLC. I will be addressing the procedural aspect of this dispute, and my co-counsel, Ms. Leila Ibrahim, will be addressing the merits of this dispute. The parties conclude a contract for the sale of the endangered species, the vanilla orchid. Non-completion of that contract was due to factors beyond the control of respondent. Claimant, upon learning of the newer procedural rules, found a singular email to settle upon and stated that the 2016 rules is the reason as to why the newer rules cannot apply. In light of this, respondent has two submissions. The first being that the tribunal must ask that the SEAC 2025 rules are the correct rules to this dispute, and second, that the tribunal should mandate disclosure of claimants' third-party funding agreements between Litshore and ATJ funding, respectively. Beginning my first submission, I would like to direct the tribunal to page 13 of the bundle, page 15 of the digital copy. Is the tribunal with me? Yes. At the very end of the page, we find our dispute resolution clause. The last line of the clause reads as, in accordance with the current arbitration rules of the Singapore International Arbitration Center. Respondent suggests that the inclusion of this word current, and more importantly, the drift from the model clause, signifies us solely towards the SEAC 2025 rules. Rule 1.5 of the SEAC 2025 rules unequivocally state that unless the parties agree, after 1st January 2025 shall apply the SEAC 2025 rules respectively. Furthermore, Rule 6.3 of Yes, Mr. Arbitrator?
No, c'è pas là.
I believe there might be a technical issue. Oh, sorry. Turning back to my submissions, respondent proposes that Rule 1.5 of the SEAC 2025 rules applies to this dispute, and secondly, that Rule 6.3 of the 2016 rules and 3.3 of the 2025 rules state that the date of receival of the request of arbitration shall be deemed the date of the commencement. 31st July 2025, as seen on the very first page of this bundle, is the date of receival of this request for arbitration, which is why respondent states that the only correct rules shall be the 2025 rules. Furthermore,
Counsel, sorry to interrupt you already at that stage. There are 2 points. You said they have used a different clause. They have not used the model clause here. Isn't that a clear indication that they wanted to deviate? They knew the model clause and they wanted to deviate from it. Yeah. What is the reason why we should not read the current as something important? And second, directly thereafter, you said they started 31st of May, but again, they have a special provision, yeah, or they discussed a special provision that it should already start with a mediation.
to answer Mr. Arbitrator's question, we shall go to the source of both the inclusion of this word current and reliance on this RMEDA protocol. On page 21 of the bundle, which is Claimant Exhibit C7. Is the tribunal with me? As Mr. Arbitrator rightly opined, this email is the source of drift from the model clause and reliance on the RMEDA protocol. Now, the email is from a third party whose name is Ms. Nicola Gobley, who was the head of contracting at respondent's predecessor, which is Botanical Garden. Now, respondent proposes that the drift from the model clause and furthermore inclusion of this RMEDA protocol applied solely to the contract between Botanical Garden and claimant. The new sales agreement between respondent and claimant does not carry either of the intentions bared with this email, as the first agreement was clearly terminated. Furthermore, claimant is likely to signify that since respondent had access to this email, they were aware of the intentions with it. However, procedural order number 2 very evidently tells us that respondent had no awareness of this, and more importantly, Mr. Albius never read this email. Lastly, with regard to the clause itself, sorry,
Counsel, when we go to Exhibit C3, the sales agreement, yeah?
Yes, Mr.
That is the sales agreement concluded between your client and the opponent. And they took in the same clause. So they must have thought something there as well, or?
Mr. Arbitrator, what respondent proposes is that the intentions bared with the original sales agreement were terminated along with the termination of their agreement, which is why respondent states that this new dispute resolution clause was accepted by the respondent and was, more importantly, not a matter of concern and was thus never amended. What respondent simply interpreted this clause as was whatever rules the Singapore International Arbitration Center proposes when a dispute arises, and more importantly, a mere two-step dispute resolution mechanism, which is what is provided to us. With regard to the dispute resolution mechanism itself, respondent would like to direct the tribunal to Claimant Exhibit C1 on page 8 specifically. Is the tribunal with me? Page 8, paragraph 8, with the second last line stating, "While I am not a dispute resolution specialist, her argument seemed convincing to me. As for us, the only relevant part of the clause was the possibility of having the dispute finally resolved in arbitration. Respondent proposes that the model clause suffices this very intention of claimant, with that of the arbitration being the final dispute resolution mechanism. Accordingly, respondent proposes that the dispute resolution clause serves all intentions that either party to this dispute have bearing. And lastly, with regard to how these negotiations are the interpreting factor, respondent states that all preliminary negotiations supersede the sales agreement itself, and thus the negotiations in that singular email cannot bind respondent at the current stage of the dispute. If there are no questions at this stage, respondent...
I have a question. I'm just wondering, what difference does it make? What's the effect? Why is it so important that we use those rules rather than those suggested by the claimant?
Madam Arbitrator, the difference between the SIAC 2025 rules and the 2016 rules lay in 25 stark differences. Respondent highlights the fact that the third-party funding powers, as per the SIAC 2025 rules, are a primary difference between the two. However, there are also differences between the general case management powers and, more importantly, general efficiency powers.
Counsel, may I also
Excuse me, are these...
even under the 2016 rules, this tribunal would have discretion to order a production of the documents. So what's the difference?
To answer your question, could I also ask Madam Arbitrator to ask her question in case it has the same answer?
It's the question that I was about to ask was a clarification, and our chair has expressed that. Thank you.
Well, to answer Madam Presiding Arbitrator's question, although the 2016 rules provide discretion to the tribunal to mandate disclosure, respondent states that the 2025 rules have explicit power, and claimant is likely to take advantage of the fact that the 27F rules within SIAC 2016 are vague, as they give general document disclosure powers. Respondent asks
Excuse me, is that not something which, if necessary, can be cured by the tribunal's order, making it specific?
Well, yes, Madam Arbitrator. However, respondent simply asks for reliance on the 2025 rules as a means to avoid further procedural delays, and as all of the fee requirements with regard to the dispute itself have been started with regard to the 2025 rules. Thus, seeing as we have already started from seeing as we have already began with the 2025 rules, respondent seeks to continue with that manner by simply asking the tribunal to declare it as such. Seeing as we move into our second procedural submission, respondent would like to state two facts. The first, that the tribunal is already aware of, that they already have the power to mandate disclosure under both the 2016 rules and the 2025 rules. Now, as for why respondent asks for these documents, there are two primary reasons. Claimant is at the brink of insolvency, and this insolvency is paired with the fact that they have appointed an aggressive funder as per page 40 of the bundle. Now, the tribunal is likely to ask, why should the funder's aggression be a reason as to why the documents must be disclosed? However,
excuse me, I'm always curious when someone uses an adjective like aggressive. And also, what's the basis of your claim that the opposing party is in financial difficulty.
Well, Madam Presiding Arbitrator, as per procedural order number 2 on page 58 of the bundle, it is clear that respondent has been facing have had a issue within their own functioning and are at the brink of insolvency as per their own statement. Procedural order number 2, clarification 20, the line clearly states, claimant is only solvent until June of 2026, which is an extremely close date. Respondent pairs this brink of insolvency with the fact that they have appointed a funder with specific characteristics, as Madam Arbitrator has opined. Now, as respondent states, these two things paired together is what creates the genuine risk of claimant's third-party funding agreements having specific terms that control the powers that ETJ funding reserves. Now, these specific powers are with regard to terms of limited liability and furthermore, terms of convenience that allow ETJ funding to depart from these proceedings at their own discretion. Furthermore,
I have a question, Counsel. Why is it important that we see the contract itself? Why isn't it enough that we just know the name of the funder or the insurer, so to make sure that there are no conflicts?
Madam Presiding Arbitrator, it is already at the tribunal's knowledge that there are no conflict of interests. However, respondent asks for these specific terms within the funding agreements as those specific terms are what cause the risk. The knowledge of the funder itself does not limit any risk that may arise with regard to the specific terms they hold for them in specific to the powers that they have. As respondent has previously stated, if the tribunal is more inclined towards simple partial disclosure, respondent agrees with such. Partial disclosure, which as previously stated, is the specific terms of limited liability and any terms of convenience that ETJ funding may bear. Lastly, with regard to respondent's absence of a security of cost application, which claimant may bring up, respondent simply states that in their response to notice of arbitration, respondent has made intentions of further submitting a security of cost application wherein the third-party funding agreement substantiates such a request.
Excuse me, Counsel, are you not putting the cart before the horse at this point? Shouldn't you ask for security for costs and give us the reasons why you think it's necessary, and then, only then, would you need to know whether there is something in the documents that you're asking for would help you or hinder you?
Madam Arbitrator, what respondent proposes as the basis for not asking for a security of cost application to begin with is due to the fact that claimant is in the precarious financial situation. A security of cost requests may cause a further holding up of their assets in their control already, and thus
have we not got a hold up already because of this part of the application? We could have gone ahead by now if we hadn't had this objection.
Well, no, Madam Presiding Arbitrator. However, before I provide further light on this answer, could I just ask for an additional 30 seconds to both answer your question and summarize my arguments? Thank you, Counsel. Thank you, Tribunal. Respondent simply states that the submission request that we have with regard to disclosure does not hold up any assets of claimant, but rather clears up any risk that may arise with regard to their funding agreements. Security of costs is what may cause these procedural delays, and thus granting of disclosure will simply resolve those concerns. Seeing as there are no questions, respondent simply concludes by stating that the relevant rules to this dispute shall remain the SEAC 2025 rules, and more importantly, the third-party funding agreements between claimant and ETJ funding and liture respectively must be disclosed to alleviate any risks that may be borne by the respondent. Thank you, members of the tribunal.
Any questions by my co-arbitrators?
One question, Counsel. You always argue that the rules shall remain the 2025 rules, but wasn't the entire arbitration initiated under 2016 rules? So your argument would in principle be, let's keep the 2016 rules then.
No, Mr. Arbitrator. Respondent is aware that this dispute has commenced with the 2016 rules. However, any cost difference that has been allocated already is with regard to the schedule of fees as per the 2025 rules, and thus application of such does not create any material difference with regard to any figures that claimant would be required to pay. And thus there is no material difference that could affect the claimant with application of the 2025 rules.
Okay.
Any further questions? As we don't have any further questions at the time being, the floor is yours. Counsel for claimant, please.
Members of the tribunal, before I proceed, am I audible and visible? Thank
Yes.
you. And with that, I would proceed. Esteemed members of the tribunal, I am Nahum Ajipon, counsel on behalf of the claimant, Orkis Worldwide Limited, in today's proceedings, addressing the tribunal on the procedural issue, while my co-counsel, Emanuela Adongo, would address this tribunal on the issues applicable to the merits as concerns the claimant. Now, members of the tribunal, in addressing the procedural issues, I would address first the applicable version of the SIAC arbitration rules to this dispute, and second, respondents' requests for the disclosure of claimant's third-party funding agreement. In doing so, I would mirror opposing counsel's submission, particularly on the first ground, and argue that the SIAC 2016 arbitration rules should apply to this dispute. First, because the parties agreed to the 2016 SIAC arbitration rules and not the 2025 arbitration rules. And second, that arbitration in this particular context began with the institution of mediation. Now, if the tribunal is with me, I would proceed onto my first ground as the parties' agreement. Members of the tribunal, by virtue of Gary Bond's work on international commercial arbitration, particularly Volume 2, we notice that by virtue of party autonomy, the parties have the right to decide the applicable version of the rules to their dispute. In this particular instance, the parties did so, and I would draw the tribunal's attention to Claimant Exhibit C3, which is the sales agreement on page 13 of the hard copy bundle and page 15 of the soft copy that the tribunal is looking. Yes, and I would read the dispute resolution clause from the second line, and I read, it says, shall be referred to and finally resolved by arbitration administered by the Singapore International Arbitration Center in accordance with the current arbitration rules of the Singapore International Arbitration.
You're muted.
You are muted.
Members of the tribunal, am I audible?
Yes, now.
Yes.
Thank you. So we agree with the respondents that the word here, current, presents an obvious ambiguity in that current does not expressly say whether the 2016 or the 2025 SIAC arbitration rules apply. Now, thankfully, by virtue of procedural order number 1, we realize that the parties may make recourse to the CISG to interpret not only the sales agreement, but also the arbitration clause.
Counsel, just may I interrupt you for a second? Before we turn to the interpretation rules of the CISG, shouldn't we have a look at the contract? And here I read definitions and interpretation. Article 1.2, interpretation. References to statutes include amendments and reenactments. Isn't that the proper interpretation for the word current?
Madam Presiding Arbitrator, no, that is not the proper word for the word current. In fact, if the parties had wanted the reenactment or the specific 2025 rules to apply, they could have just stated that. However, seeing as neither party did that, and because the intent points to a different direction, we argue that the CISG should rather be used to interpret the wording of current. Now, members
And
of the
not the
tribunal,
contract. Which one prevails if there are discrepancies between the contract and the CISG?
Madam Presiding Arbitrator, the contract does prevail. But in this particular instance, this particular definition does not lend credence to which of the rules are to apply in this particular dispute. And we also have to take that in light of the agreement of the parties and the negotiation history. And it's for this reason that we rely on Article 8. Furthermore, by virtue of the contract, the parties also agreed that the CISG should govern the interpretation of the entire contract and the sales agreement. Thus, the resort to the CISG is in the contract. And with this, members of the tribunal, we rely on Article 8 of the CISG. Members of the tribunal, under Article 8 of the CISG, a number of tests are outlined, with Article 8.1 being the subjective test and Article 8.2 being the objective test. Claimants in this particular instance would rely on the first test under Article 8.1 because by virtue of Professor Crow's commentary CISG, second edition, particularly paragraph 19 on page 7. Please, am I audible?
Breaking up.
Members of the tribunal, please, am I audible?
Yes.
Yes, please. Members of the tribunal, by virtue of Professor Crow's work, the commentary on the CISG, second edition, paragraph 19 at page 7, we notice that Article 8.2 test can only be relied upon where the Article 8.1 test or the intent of the parties cannot be ascertained. Now, in this particular instance, under Article 8.1, it is where we have one intent of the parties and then we impute that to the other party where they should have known or they could not have been unaware. In this particular
counsel, you're saying that it's only to be used if the intent of the parties is not clear, but isn't that exactly why we're here? It's because it isn't clear. And specifically, I suppose you're going to get here is what how we should be interpreting the word current, which was added by the parties.
Yes, Madam Presiding Arbitrator, the wording current here is the ambiguity. However, there are certain instances that would point us to what the parties meant when they incorporated the term current. And it's for this very reason that we're relying on Article 8.1 of the CISG. Now, members of the tribunal.
Sorry, before you continue there, that goes directly to that one as well. We heard from your opposing counsel that the wording was changed by previous parties and our parties had no really intention of changing anything. Could you address that as well, that this is irrelevant, the addition there?
Yes, Mr. Presiding Arbitrator, we would indeed address that. Now, opposing, Mr. Arbitrator, my apologies. And now opposing counsel argued that they did not accept, there was only the email that we based this particular assertion on. However, we would show that the respondent had intent or had knowledge of this particular set of facts. Now, the tribunal can please turn with me to procedural order number 2 on page 56 and page 58 of the bundle. Procedural order number 2, page 56 and page 58 of the electronic version of the bundle. Paragraph 8, the tribunal is with me. Yes, please. And I would read from the second line, members of the tribunal. Paragraph 7 on the second line. It says, she suggested to participated in an ARB-Med-ARB procedure under the SIAC-SIMC protocol. She suggested to Ms. Gobley amending the model clause to start directly with mediation, assuming that through the use of the amending protocol, the mediation would begin. Members of the tribunal, I apologize. It's paragraph 8 of the fact. The tribunal is with me, not paragraph 7. If the tribunal is with me.
I have a problem. You are relying on evidence that is not in the contract itself. And my question is, does the contract contain an entire agreement clause?
Yes, Madam Presiding Arbitrator, it does contain an entire agreement clause. However, these clarifications are supplementary to the terms in that particular contract. In that the entire agreement clause applies to the sections on the sales agreement and does not extend to the dispute resolution clause. And for this reason,
I'm sorry, yes, counsel. Yes, the whole contract, including the dispute resolution clause, is called sales agreement. So the dispute resolution clause is part of the sales agreement. So why not applying Article 2.4 exclusive terms also to the dispute resolution clause?
Madam Presiding Arbitrator, we seek to make recourse to procedural order number 2 because the contract itself is not conclusive of what the parties meant exactly. And for this very reason that we're seeking to establish the intent of the parties. Members of the tribunal, under paragraph 8 of the fact, particularly line 2, it says, claimant's template used for botanical garden contract, to which a new clause 15 had been added at the time, was otherwise acceptable to Mr. Albius. From this, we notice that when the respondent took over the affairs of the Equatorian Botanical Gardens, it had the opportunity to make certain amendments in certain regards. and it amended it in only three regards: the name, the delivery flexibility, and the quantity, leaving intact the clause agreed to by the claimant and the Equatorian Botanical Garden, in which it indicated was acceptable. Members of the tribunal, aside this—
Excuse me, is there any, do you have any information as to whether there was a discussion of that clause at any time?
Madam Presiding Arbitrator, could you please come over again?
Do you have any information for us about whether that clause was actually discussed, or was it simply not mentioned at all, and so therefore you're saying that it was accepted?
Madam Arbitrator, the clause was not discussed between the parties in this particular dispute. However, by virtue of Article 8, we must first establish the intent of one party. Now, the intent of claimant is that the 2016 rule should apply. And the second test is that the other party should have known or could not have been unaware. So our argument in this particular instance is that respondents could not have been unaware of the intention to use the 2016 SIAC arbitration rule. Furthermore, as
I'm sorry, but I'm not following that. I thought we were going to be talking about what current meant, and you're assuming that we have decided already that current is something which is basically dynamic. It changes with the time.
No, Madam Presiding Arbitrator, we do not seek to argue that current in this particular instance is dynamic. Rather, we seek to argue that current should be used in light of the rules that were read by Ms. Gobley at the time of contracting, because it is that intent that claimant shared, and Article 8.1 is an intent that the respondent should have known. Additionally, we would notice that respondent's director was a member of the board of Equatorian Botanical Gardens at the time when the approval was given for the 2016 SIAC arbitration rules to govern the arbitration. Thus, members of the tribunal, the facts point to one fact, that the respondents cannot say that it could not have been unaware of this intent by claimant, more so when it amended the contract in certain parts but left the dispute resolution clause intact. With this, members of the tribunal, we argue that the arbitration began with a mediation in that it was a modified AMA clause and it was not two separate procedures. Thus, where mediation can stay an arbitration, where it can cause a settlement reached in a mediation to be consolidated into an arbitration, it forms part as one unified process termed as the ABMED-AB protocol. And seeing as the Equatorian Botanical Gardens did not want to cede to the jurisdiction of external bodies, it requested that arbitration be made the last resort and arbitration be resorted to as least as possible. Thus, the parties modified the AMA protocol to make it a modified AMA protocol beginning with mediation. Members of the tribunal,
but
with this—
Counsel, sorry to interrupt you once more. I have two questions. The first one is, we also asked your opponent, why should we really be concerned? In 2016, 2025, does it really want this case solved as quickly as possible? And we have to deal with that. That's one thing. The second thing is, didn't SIAC already decide when the arbitration started? Isn't there a decision by them? It started at one point in time, and so they don't interpret their own clauses in a way that it starts with the mediation.
Yes, Mr. Arbitrator, I would answer your question in the turn in which they were asked. Now, on the first issue as to why should we be concerned, in fact, either under the 2016 SIAC arbitration rules or the 2025 arbitration rules, particularly on the issue of disclosure, this tribunal has the power to order disclosure. However, the scope under the 2016 rules is narrower than the scope under the 2025 arbitration rules. Now, it is indeed true that the tribunal decided on the applicable SIAC rules. However, they gave the discretion to the tribunal to determine the applicable rules based on the arguments of the parties. Now, seeing as I have 30 seconds left, I would request an additional minute to address the tribunal on my second issue. Thank you, members of the tribunal. Members of the tribunal, the second issue, which is respondents' request for the disclosure of claimant's third-party funding agreement, would be argued on two grounds. First, that disclosure has been met under the 2016 SIAC arbitration rules, and then further, under the 2025 SIAC arbitration rules, no further disclosure is warranted. Members of the tribunal, under the 2016 rules, particularly Rule 19 and Rule 27.f, the tribunal has the power to order for such disclosure. However, we notice that by virtue of the SIAC practice note on external funding, pages 2 of paragraph 21, that this is limited to the existence and the identity of the third-party funder, both of which the respondent acknowledges that claimant has met, and thus no further disclosure is warranted under those rules, which ties into the second argument under the 2025 SIAC arbitration rules. Now, members of the tribunal...
Excuse me, a question.
Yes.
What's the basis, aside from the fact that we may or may not make this order, what's the effect of an order that we make on your client? Why does this matter?
Madam Arbitrator, it matters in this particular instance because that is a document of confidentiality that contains certain terms between the claimant and its third-party funders, and that should not be disclosed in this particular instance. In any instance...
Excuse me, but that clause says it's confidential except as ordered by a judge or arbitrator, right?
Yes,
so isn't that kind of circular reasoning?
Yes, Madam Arbitrator, unless otherwise disclosed by a judge or an arbitrator. However, we argue in this particular instance that there is no grounds to warrant this particular disclosure. With this, we understand that respondent raises the argument of impecuniosity in this particular instance. However, that risk, as indicated by the respondent, is mitigated by the presence of late shows agreements. That's the insurance coverage for the after the event insurance. Now, in any instance, because of this particular adverse cost coverage, there's no need to disclose ATJ's funding. In any instance there, if the tribunal is trying to ascertain the extent of this coverage by literature, there are less intrusive ways to determine this, like requesting claimants get an affidavit from the insurer indicating the percentage of coverage. Thus, other confidential terms in the agreement would not be made bare to the entire public. And it's for this very reason that we argue that there are less intrusive ways and the tribunal should not order disclosure of the entire agreement of claimant's third-party funding agreement. Thank you, members of the tribunal.
Any further questions by my two co-arbitrators? No? Then, counsel for respondent, you have the possibility to rebut and you have 2 minutes for rebuttal.
Taking her out.
Thank you, Madam Presiding Arbitrator. The route of the road is laid out before the journey has begun. The claimant opened up by stating that they rely on the principles of party autonomy and what the dispute resolution clause itself says. However, respondent notes that the clause does not say 2016, nor does it say ARB-Med-ARB protocol, and more importantly, there was no reference to an ARB-Med-ARB protocol when mediation finally began. Thus, all signs of party autonomy can only lead us towards the SIAC 2025 rules in that the dispute resolution clause states. Secondly, with regard to claimant voluntarily relying on Article 8.1, it is unclear as to where their basis for this application was found, seeing as Article 8.1 sets the threshold of neither party being unaware of such intent. Procedural order number 2 has quite evidently told us that it is unaware as to whether a respondent ever saw these emails, and more importantly, that Mr. Edmund Albius never did. Claimant has effectively tripped over their own feet in relying on this Article 8.1 and thus cannot apply cannot apply such protocol to understand that the 2016 rules must apply to this dispute. And lastly, with regard to the third-party funding agreements, claimant also relied on Practice Note 5, stating that it only asks for the identity of the funder to be disclosed. However, this is evidentially wrong, as the tribunal does have the power to mandate disclosure of the funding agreements where the tribunal find necessary or expedient. Expediency, which is clearly found in the fact that claimant is at the brink of insolvency, as stated by respondent. Thus concluding respondent's rebuttal.
Thank you very much. Any questions for counsel for respondent on rebuttal? Then counsel for claimant, you have the possibility of a rebuttal. Also 2 minutes, please.
Thank you, members of the tribunal. I would make my rebuttal on 3 points as addressed by opposing counsel. On the first ground, opposing counsel mentioned that there is no explicit reference to the AMA protocol. That is indeed the case. However, the parties demonstrated a clear intent to amend the original AMA protocol to a modified AMA protocol, and that was the intent that claimants proceeded with. In any instance, this ties into the second submission of the respondent that they do not know the basis upon which Article 8.1 is relied upon. Now, the basis for the reliance on this is procedural order number 1, and as was stated by Professor Crow in his commentary on the CISG, is the first test to be relied upon before moving to the Article 8.2 test. Now, seeing that the intent of claimant is known in this particular instance, the 2016 SIAC arbitration rules apply. Then we then have to look to two circumstances. And opposing counsel in this case argues that there's a requirement for actual knowledge. However, that is not the wording of Article 8.1. Article 8.1 indicates where the party knew or could not have been unaware. Thus, there's the element of imputed knowledge where surrounding circumstances would point to the fact that there was a possibility of respondents to furnish itself with those relevant facts, but did not. Now, finally, onto the issue of the third-party funding agreement. We do agree that the tribunal can order further disclosure beyond the identity and the existence of the third-party funder. However, this is not warranted in this present case. We understand respondent makes the argument that because of claimant's brink of impecuniosity, this is warranted. However, after the event insurance by Litio mitigates this risk, and in any instance, if the tribunal is not satisfied with this, less intrusive method like an affidavit from Litio stating what exactly they've undertaken to cover exists. Thank you, members of the tribunal.
Thank you very much. Any questions by my two co-arbitrators to finalize our discussion of the procedural issues?
Just one question out of curiosity to claimant. We heard a number, sorry, to respondent, we heard a number of proposals from claimant what they would be willing to disclose. Would that be sufficient for you? Then we can avoid the entire decision here.
Mr. Arbitrator, as respondent has opined, partial disclosure of the specific terms that were requested by respondent is perfectly suitable to us.
Okay, thanks.
Thank you. Professor Barrington?
No questions, thank you.
No question. Then we now turn to the substantive questions of this case, and counsel for claimant, you may start. You are muted.
Good day, honorable members of this tribunal. My name is Emanuela Adongo, and I appear before you today on behalf of claimant, Orchids Worldwide Limited, to present to you on the merits of this dispute. Members of this tribunal, imagine a pilot who mid-flight is alerted the fuel levels are critically low. The alarms sound and the dashboard flashes. Alternate airports are also well within reach. However, this pilot chooses to stay the course. When the engine eventually fails, the cause is not fate, it is choice. So too in the present case. Respondents were given clear, timely warnings and viable opportunities to act. However, they failed to do so, and as such, must be held liable for the resulting breach. It's against this background, members of this tribunal, that we're making two submissions. First, that respondents' liability for failing to perform their part of the agreement is neither excluded under Article 12 of the Sales Agreement or Article 79 of the CISG. And further, that this honorable tribunal should find respondents liable to claimant in the amount of 3.3 million in damages as the price difference between the original contract and the cover sale. Turning to the first ground, members of this tribunal, Article 6 of the CISG allows parties to derogate from the provisions of the CISG. However, CISG jurisprudence consistently holds that such derogation must be expressed. It's on this basis.
Excuse me, counsel, I don't know any case stating that derogation must be explicit. Can you give me an example for case law?
Yes, Madam Presiding Arbitrator. In the Court case 277, held by I believe the International Chamber of Commerce, it was held that the party's insertion of a force majeure provision in the sales agreement, which was non-exhaustive, could not be deemed as an exclusion of Article 79 of the CISG. The facts of this case is very similar to the present one. I'd like to refer this honorable tribunal to page 13 of the record. That's page 15 of the PDF version under paragraph 12 of the sales agreement. If this tribunal is with me there. Page 13 of the record, that's page 15 of the PDF version. And I read, a party is not liable for a failure or delay caused by events beyond its reasonable control, including but not limited to acts of God. Then the list continues. This clause that shows that the parties did not intend to exhaustively govern the area of force majeure, and to that extent, this clause must be read in conjunction with Article 79 of the CISG.
Sorry, I cannot follow you, counsel. Why should we supplement Article 12 by Article 79 of the CISG? I mean, the parties have inserted a force majeure clause into their contract that deviates from Article 79. And in my view, that's enough to show their intention that they wanted to deviate from Article 79.
Indeed, Madam Presiding Arbitrator. However, as stated earlier, CISG jurisprudence has consistently held that where parties intend to exclusively govern their agreement by their sales agreement or to exclusively leave out the provisions of the CISG in governing the agreement, it must be said so or stated expressly by the parties.
But counsel, I imagine almost every international sales contract has Incoterms. And with your suggestion, it would mean that the parties who insert Incoterms in their contract have to explicitly state that the rules on passing of risk of the CISG are thereby excluded. I've never seen such a contract. So in all the cases, the Incoterms wouldn't prevail over the rules of passing of risk of the CISG. Is that your suggestion?
No, Madam Presiding Arbitrator. Indeed, where parties include Incoterms in their sales agreement, it should prevail over the terms of the CISG to the extent that it exclusively governs the rights of the parties with regards to the sale and delivery of the goods. However, this situation is different. This is because the force majeure clause included in the sales agreement was not exhaustive. To the extent that this clause exhaustively governed the rights of the parties in a force majeure event, then indeed this force majeure clause would supersede the CISG.
Sorry, counsel, I'm sorry, it was not exhaustive. What do you mean?
Madam Arbitrator, from the clause just read, it states that a party is not liable for failure or delay caused by events beyond its reasonable control, including but not limited to. Thus, it opened the way for inference and the interpretation of Article 79 of the CISG to be made in supplement to this clause.
But this clause is even more precise than Article 79 that only speaks about impediment.
Indeed, Madam Presiding Arbitrator. However, the rationale behind respondent's claimant submission is that to entirely rely on this force majeure clause would reduce the force majeure proof or burden to an unacceptably low level, considering that all the party has to prove is that there was a government measure. However, force majeure events go beyond that. A party must prove that this force majeure event was one that, as a matter of fact, inhibited or prevented them from performing, such that the mere fact that the event in question was a government measure does not exculpate a party without proof that this impediment indeed barred them from performing their part of the agreement. And this is why members of this tribunal, they will submit that the Clause 12 agreement should not be read in isolation, but in tandem with Article 79 of the CISG. Members of this tribunal, having established this, it's a further submission the respondent moreover fails to meet the 4 elements provided for under Article 79 of the CISG. Article 79 provides that a party must prove that the impediment in question was beyond the parties' control. It must have been unforeseeable. It must have been the cause of the parties' failure to perform, and it must have also been unavoidable. In the interest of time, members of this tribunal, claimant will seek to disapprove just one of these elements, thus barring respondents' reliance on this provision. Members of this tribunal, the element of avoidance provided for under Article 79 provides that a party must take all reasonable steps to overcome an impediment. This, according to the case of Macromes and Globex, includes all reasonable alternatives, even where such an alternative would impose higher risk on the party. Members of this tribunal, in the present case, respondent had two main alternatives in overcoming the impediment, either applying for an anticipatory permit or taking early delivery of the vanilla orchids. However, they failed to utilize both options without reasonable justification. With regards to the application for an anticipatory permit, respondent relied on the 90-day period, which generally lapses before site resolutions are enforced in party states. However, such reliance can be said to have been unreasonable, considering that at the
Sorry,
same
did you say,
time,
excuse me, did you say that reliance was unreasonable?
yes, Madam
Thank you.
Arbitrator.
I didn't catch it. I wasn't sure whether you'd said reasonable or unreasonable. Thank you.
Thank you, Madam Arbitrator. This is because at a conference where it was recommended for the reclassification of the vanilla orchids from Appendix II to Appendix I, it was further recommended for the abandonment of the 90-day period, which generally lapses before site reclassifications take effect. On that basis, there was no reasonable justification for respondents to continue to rely on the 90-day period when it was evident that it could be abandoned. Members of this tribunal, with regards to the alternative of taking early delivery of the vanilla orchids, respondent failed to do so, relying on the fact that doing so would have amounted to extra cost. This cost being the double delivery cost, as well as the possibility of storing the vanilla orchids in storage containers. Indeed, members of this tribunal, the option of storing the vanilla orchids in the storage containers would have amounted to such risk that claimant does not expect respondent to undertake. However, with regards to the option of storing the vanilla orchids in the old greenhouses, that option was viable, considering that it is stated in Procedural Order Number 2 that no form of loss would have arisen unless after a period of 3 years. To demonstrate this, I'd like to refer this Honorable Tribunal to Procedural Order Number 2 on page 57 of the record and page 59 of the PMD version, PDF version, reading from paragraph 15. If this Honorable Tribunal is with me there. Reading from the 7th line, it states that planting in old greenhouses will not result in immediate loss, but it was very likely that over the course of 3 years, more than double of the number of orchids would be lost. Thus, members of this tribunal, the greenhouses that respondents had contracted for were scheduled to be made available only 2 months after this scheduled early delivery. Thus, this loss over the span of 3 years would have never actually materialized, considering that the new greenhouses would have been made available and the vanilla orchids could have been stored in there. It's on this basis that we submit that respondent steered right through every possible warning given, despite the availability of alternate airports, and as such must be liable for the resulting crash. Having established this, members of this tribunal, we further submit under issue D that the basis for the calculation of the awardable damages should be Article 75 of the CIHD, since all the required elements have been met. Members of this tribunal, Article 75 of the CIHD provides that a cover sale must be concluded after the avoidance of the original agreement, and further that it must be concluded within a reasonable time and manner. These elements, as claimants would show, are fulfilled or met in the present circumstances. Members of this tribunal, on 10th of February 2024, respondents made it known to claimants that it would be impossible for them to attain the import permit which was necessary for delivery to take place. Further, on the 15th of February, it was made known to the public that respondents had put up their entire spice line, for which reason they had entered into the agreement up for sale.
But
Considering these two,
Counsel, can we agree that that the cover sale was made before the avoidance of the contract, before the formal avoidance of the contract?
Madam Presiding Arbitrator, seeing that I have a minute more, I kindly request an additional minute to answer your question and wrap up on my argument.
Please.
Thank you, Madam Presiding Arbitrator. Indeed, the avoidance was claimant submission is that the avoidance did not take place before the conclusion of the cover sale. This is because Article 11 of the CISG provides that the conclusion or otherwise of an agreement between the parties is not subject to any requirement as to form or writing. This provision was supported in the iron molybdenum case, where the tribunal held that where a party shows their inability or refusal to perform their part of an agreement, it justifies the conclusion of a cover sale on the basis of Article 75 of the CISG, in line with a party's duty to mitigate loss.
Counsel, if we were to stick to the wording of Article 75, do you have an alternate submission?
Madam Presiding Arbitrator, this is the submission being made by claimant on the basis that the communication by respondent on 10th of February that it would be impossible for them to attain the import permit was in essence an implied avoidance of the agreement, justifying claimant's conclusion of the cover sale on 15th of February 2024, members of the tribunal.
If we were not to follow your line of reasoning, would your party be satisfied if we were to rely on the market price?
No, Madam Presiding Arbitrator. This is because calculation of the awardable damages on the market price would indeed defeat the purpose of damages. This is because the rationale behind the awardance of damages is to place the party in the position they would have been had the agreement been performed. However, in the present case, claimant produced the entire amount of 3,300 vanilla orchids, which was priced at 2,000 USD under the original agreement. As such, to calculate the awardable damages on the basis of 1,100 USD, which was the prevailing market price, would place the claimant in a position that is unfavorable than what would have been if the agreement had been performed. It's on this basis, members of this tribunal, that we submit that this honorable tribunal finds in favor of claimant and award the damages of 3.3 million. Thank you.
Any questions for counsel for claimant on substantive issues?
No further question from my side.
A little unclear about what you're telling us in terms of the basis for calculation. Could you just run that by us again? If we don't accept the idea that the cover followed avoidance, can we still use Article 75, or is it excluded and we go only to 76?
Madam Arbitrator, our submission is that even if this honorable tribunal does not agree to the fact that avoidance took place before the cover sale, Article 75 of the CISG is nevertheless applicable to the extent that it has been held under the CISG jurisprudence that a party's refusal to perform their part of an agreement is implied avoidance capable of entitling a party to rely on Article 75 of the CISG despite the express avoidance of the agreement. And this submission is in line with the party's duty to mitigate loss under Article 77 of the CISG.
So 76 is out then?
Yes, Madam Arbitrator.
Thank you.
Any further questions? If this is not the case, we now turn to counsel for respondent. Please, the floor is yours. You are muted. Thank you.
Members of this tribunal, good evening or good afternoon. As my co-counsel has previously stated, my name is Leila Ibrahim, and I'll be appearing on behalf of respondent Darwin Natural Food PLC, addressing the merits of this dispute. Unforeseen regulatory changes in Equatoriana have affected respondent far beyond its contractual obligations, and while respondent was assessing the situation, claimant acted prematurely and now seeks to point fingers at respondent. In light of this, mirroring my opposing counsel, I'll be making two submissions. First, that respondent is exempt from liability, both under Article 79 of the CISG, as well as the force majeure clause under the sales agreement, followed by my second submission that claimant is not entitled to damages pursuant to Article 75. Beginning with my first submission, that respondent is exempt from liability under the force majeure clause as well as Article 79 of the CISG. The non-exhaustive clause, members of the tribunal, under Clause 12.1 of the sales agreement includes government measures as an impediment that is beyond a party's control. This element, beyond an impediment being beyond a party's control, is also reflected in Article 79 of the CISG. Here, the sudden change in Equatoriana's government stance in regards to issuing a import permit constitute as such. Following on to the clause 12.2, respondent has also met this condition.
I think, counsel, this has not been disputed by claimant. Rather, claimant relied on the question that it was avoidable, that the consequences of this impediment could have been overcome by respondent. So could you please address this question?
Noted, Madam Presiding Arbitrator, I shall be addressing Article 79, the unavoidability criteria. This criteria...
Counsel, you heard our discussion between the tribunal and counsel for claimant about what to apply, Article 12 or Article 79. Are you primarily relying on Article 12 of the contract or on Article 79 of the CISG? And if there is any discrepancy between the two, which one does prevail, actually?
Madam Presiding Arbitrator, it is respondent's contention that both Article 79 as well as Clause 12 of the sales agreement are to be interpreted harmoniously.
And why?
This is because the parties have included the Clause 12 into the sales contract, and it does contain similar elements to Article 79. Therefore, Article 6
Wouldn't it be more beneficial for your party if we were to interpret Article 12 autonomously without regard to Article 79?
Madam Presiding Arbitrator, it is respondent's contention, irrespective of the method used, be it Article 79 or the Clause 12, the conclusion will be the same, that respondent is exempt from liability. Addressing the unavoidability criteria under Article 79, it turns on whether a party could reasonably be expected to have avoided the impediment or any of its consequences. The keyword here, members of the tribunal, being reasonable. Claimant provided respondent with two options. First, to apply for an anticipatory permit in November 2023, or to accept an earlier delivery in January 2024 instead of the planned delivery date in March 27. Members of the tribunal, it is respondent's contention that these two options were unreasonable. Beginning with the anticipatory permit. Back then, in November 2023, it was a mere suggestion by the plans committee that the 90-day grace period would be shortened or abandoned. It was not even sure that this decision would materialize, considering Equatoriana and Mediterranean's strong opposition to this recommendation. Furthermore, the immediate application of a site's application has never been invoked before. And even if it was, members of the tribunal, Equatoriana was known to comply very leniently with any of site's obligation. This would have led respondent to believe that it would not adopt any stricter national measures. In the case that these orchids were to be uplisted into Appendix 1, members of the tribunal, I invite you to look at Article 7, Paragraph 4 of the CITES Convention texts. And it states that plant species included in Appendix 1 that were artificially propagated for commercial purposes shall be deemed to be species included in Appendix 2. This exemption would apply to the vanilla orchids under the sales agreement because a significant amount of the orchids under this agreement were artificially propagated. Therefore, it was reasonable to infer that respondent, back in November 2023 for the above reasons, would not have deemed it necessary or obligatory in that fact to apply for an anticipatory permit. Now, regarding the option of an earlier delivery, respondent invokes the concept of hardship to also show that this alternative was unreasonable. Under the reasonable expectation tests, member of the tribunal, a party may be exempt from liability under Article 79 of the CISG if the financial loss they would incur is far greater than the risk a reasonable person would anticipate at the time of contracting.
Counsel, can you please specify all the costs that your party would have incurred in case of a premature delivery?
Yes, Madam Presiding Arbitrator. So if respondent would have accepted an earlier delivery, the transportation costs would have doubled or tripled, and the energy costs would
So
have
how much
tripled.
is that in dollars?
So the transportation cost would have been around $300. This is because if we were to multiply 50, the transportation cost by 2, in light of the vanilla orchids to be delivered, it would equate to $300. This amount may appear insignificant. However, if respondent were to also accept an earlier delivery, they would have incurred a loss of 20% of the vanilla orchids if these were stored under the transport containers.
And that
this would have equated,
would amount to which figure?
It would have equated to almost $1 million. Now, in light of all this, respondent could have technically accepted a delivery and stored it into their existing greenhouses, but that option was also not viable because had they accepted a delivery in January, at the time where they have been targeted by ecological activists, they would have exposed respondent to further reputational damage, which was a risk respondent would not be willing to take for an event that's yet to be materialized. It is for these reasons, members of the tribunal, that respondent could not have avoided the impediment and is thus exempt. Proceeding with my second submission, that should the tribunal grant claimant any damages, it should not be done pursuant to Article 75 of the CISG. This is because Article 75 lays out 3 conditions for a party to fulfill in order to claim damages. First, that the avoidance of a contract be declared before entering into a subsidy transaction. And second, that the subsidy transaction be concluded in a reasonable manner. Third, that said transaction is concluded within a reasonable time. Seeing that claimant invokes Article 75, the burden of proof rests on them. Claimant failed to declare the contract avoided before entering into its substitute transaction with Herbal Cosmetics.
But counsel, you heard claimant rely on case law as well as on authorities that all agree that if there is an avoidance or a failure to perform by the other party, by the buyer, the seller has a right to do a cover sale. It might even be obliged under Article 77 to make such a cover sale.
Yes, Madam Presiding Arbitrator. Claimant cites respondent's response on February 10th as an express refusal or the date where they failed to perform their contract. To answer this question, members of the tribunal, I direct you all to page 16, which is Claimant Exhibit 6, Bernard Harmon's witness statement. If you're using a digital bundle, that would be page 18. We'll be looking at paragraph 4, the third line. If the tribunal is with me, I may begin. It reads, he also expressed doubts about whether it would be possible at all to obtain an import permit under the new circumstances. What claimant has conveniently left out in the following paragraph is that respondent informed claimant that they would get back to claimant in light of all these developments and provide a final response. Respondent claimant has gone against the explicit wording of Article 75 and concluded a substitute transaction before declaring the contract avoided. Even if an express refusal has been made, members of the tribunal, the aggrieved party, the injured party, or a claimant in this case is still expected to declare the contract avoided, as seen in the ICC case 8574, where the tribunal did not grant the aggrieved party damages, seeing that the buyer or the injured party did not declare the contract avoided before entering into a substitute transaction.
But counsel, even if we were to follow your argument, couldn't this tribunal base the damages on Article 74 and also come to the result that the amount should be in the amount of the cover purchase?
No, Madam Presiding Arbitrator, Article 74 does not apply in this present situation, seeing that Article 74 only applies to where the contract price is fixed. Seeing that the tolerance clause includes a variation of plus or minus 10%, it cannot be said that the sales agreement has a fixed contract price. It is thus respondent's contention that both Article 74 or 75 does not apply to claimant.
Okay.
Members of the tribunal responded.
Sorry, counsel,
yes.
You may have lost me there. 74 says, you say it doesn't apply because there is no fixed contract price.
To clarify my statement, Mr. Arbitrator, respondent states that Article 74 applies to where the contract has a fixed price. Respondent's contention in this present case is that the sales agreement does not have a fixed contract price. This is why claimant cannot claim damages under Article 74.
Where do you get that from, that Article 74 only applies if there is a fixed contract price?
This would be based on commentaries, Madam Presiding Arbitrator.
Which commentary?
At the present moment, seeing that my time is about to elapse, Madam Presiding Arbitrator, respondent simply asked that the tribunal still declare that Article 75 or any other provision does not apply to claimant, saying that they failed to
sorry, can you please answer my question? Which commentary are you relying upon regarding the submission that Article 74 only applies if there's a fixed contract price?
Madam Presiding Arbitrator, while I don't have that commentary at hand, respondent simply makes the contention that neither provision applies to claimant. Seeing that I have a minute left, I'll simply move on to my final ground, is that should the tribunal amount to claimant any damages, it should be done by taking the lower end of the vanilla orchids, which is 2,700. Members of the tribunal, the tolerance clause under the sales agreement does not grant any party the right to decide the exact amount of vanilla orchids to be delivered. However, if that right is granted, it should be done to respondent, seeing that they have decided the exact delivery time, they have organized the transportation, and in light of all these events, it's only natural for them to have decided the exact number of vanilla orchids. I thus conclude my submission and also respectfully request the tribunal to declare the respondent exempt from all liability based on Article 79 of the CISG, as well as the force majeure clause, and that claimant's claim should be dismissed entirely. Thank you all.
Thank you very much, counsel. Any questions by my co-arbitrators?
Not directly to that, but more for the rebuttal. Yeah, I would be very happy if counsel for claimant could address in the rebuttal the number 2,700, 3,300. Yeah, if we award damages, what should be the relevant number of orchids?
Professor Barrington, any question for counsel for respondent?
Not at this point. I'd like to hear the rebuttal. Thank you.
Thank you very much. Counsel for claimant, you may rebut this argument. You have 2 minutes, and you heard the request by Professor Krell to address the question of the amount of orchids.
Thank you, Madam Presiding Arbitrator. Honorable members of this tribunal, it is claimant's submission that the basis for the calculation of the awardable damages should be the amount of 3,300 vanilla orchids and not 2,700. This is because the addition of the provision plus or minus 10% was included in the agreement in order to safeguard against propagation losses over which claimant had control, thus making them the right party to determine the number of orchids to be delivered. Members of this tribunal, under the cover sale between claimant and Herbal Cosmetics, claimant was in fact able to grow and deliver the entire amount of 3,300 vanilla orchids. As such, for respondent to argue that the number to be used is 2,700 vanilla orchids is mere speculation, and as such, we submit that this honorable tribunal finds that the number which claimants in fact produced, that is 3,300 vanilla orchids, should be used. Thank you.
Any further questions? Counsel for respondent, you have the possibility of a sir rebuttal. Also 2 minutes, please.
Members of the tribunal, the tolerance clause does not grant either party, claimant or respondent, to decide the exact number of vanilla orchids. And if the tribunal were to look at this amount to calculate damages, it would mean that claimant has met Article 75's conditions. It's simply respondent's contention that they have not. They've went against the explicit wording of the provision and now seeks to put respondent under further burden for an impediment that it is exempt from. Thank you, members of the tribunal.
Thank you very much. Any questions from my co-arbitrators? No questions. So thank you very much, counsel for both sides. Before I close our hearing, I wanted to ask you whether you had the possibility to equally present your case and whether you have been treated fairly by this tribunal.
Yes, Madam
Yes, we
President.
have members of the tribunal.
Thank you
Yes,
very
members of
much.
the tribunal, the claimant has also had the opportunity.
Thank you. And with this, I hereby close our oral hearing and again thank both sides for their cooperation. Thank you.
Thank you very much.
Thank you very much to our esteemed tribunal and to University of Ghana and Middlesex University Dubai. The tribunal will now retire to deliberate. Those of you that are watching, you're free to stay on the Zoom or on the YouTube link. The awards and the closing ceremony are to begin at 6 o'clock Central European Summer Time, which I note is about 40 minutes away. So by the time deliberations are complete, we'll come back onto the Zoom and you'll be able to see how we are progressing. I think we're a little ahead of time, which was unexpected, but always a good thing. So we'll be back with you shortly.
Congratulations to both teams. Listening in, very good. I don't envy the arbitrators having to decide.
Very kind of you.
It's completely sincere.
Thank you
Yeah,
very
I
much.
concur too. It is difficult.
Yeah, not easy, definitely not. Elijah, where are you at?
I'm in Los Angeles, but I'm from Uganda.
Ah, okay. So it's early in the day for you yet.
Yeah, I was here since midnight.
Okay.
Now it is 8, coming to 8:30.
Okay.
Yeah.
Well, you should be happy to see University of Ghana in the final then, I think.
Yeah,
Another
I
African
saw
team.
them from the semifinals, but I had one of the teams as a panelist on one of the teams in the round 3.
Okay.
Yeah. So I got curious to see how Africa is performing.
Usually, I mean, there's some, I mean, so I think, but University Makerere sometimes